Hi, good evening everyone. I am Khushi M. Singh, the founder of Lotto, and I am delighted to welcome you all to today's session on how law students can prepare for arbitration practice. So today we are honored to join by Advocate Mr. Hitesh Ramchandani sir, who is an arbitrator, counselor, and mediator, which is associated with several international institutions. So it's an honor to have him with us today. So without taking too much time, I would like to request Mr. Hitesh Ramchandani sir to kindly begin the session and guide us with this important topic. So now this session is over to you, sir. Am I audible?
Thank you, madam. Thank you everyone for joining this session, and I wish everyone that there is a great enthusiasm in everyone's mind to start up their careers into an arbitration practice. So I truly feel that attending this lecture, you will be very confident that how you can start up your own practice or how you can start up your journey, a career into this arbitration practice. So I'll be sharing you with the PPT. I have also made a PPT so that it will be very useful to you. Just a minute, I'll share my PPT. Is everyone able to view this screen?
Yes, sir.
Yes.
So is everyone able to view my screen now? Hello?
Yes.
Yes, sir.
Basically, must be thinking that as to what is an arbitration. See, basically, arbitration is a private dispute wherein both the parties approach a neutral person who is an arbitrator to decide the case. So, in this way, it is a very speedy justice. The matters can be decided in a very speedy manner, and as well as it is a cost effective, because if you go into the courts or you take the matter into a litigation, then it will take years and years of time. So arbitration is a very important tool in our in India and as well as the global system, wherein matters can be resolved immediately. I mean, it can be resolved within a year, because there are certain aspects which have been mentioned into an arbitration act, wherein after completion of the pleading within 1 year, an award has to be passed. So within 1 year, you will get an award by an arbitrator. So basically, in this way, the key features of an arbitration is that where the parties appoint an independent person who is a neutral and who is being stated as an arbitrator. Okay, so the proceedings can take place outside the traditional court system, and it is very flexible, wherein the party it is also a party autonomy, wherein the party has the freedom to choose the seat. The party has the freedom to choose the arbitrator. So by consent of both the parties, an arbitrator is appointed, and the award is binding on both the parties. So the arbitration is widely used in commercial contracts, construction agreements, international trade transactions, and investment disputes. So nowadays you will see that majority of the contracts, the international contracts, do have the dispute resolution clauses which mentions about the first aspect, that is negotiation. If the negotiation fails, then it will escalate to mediation. If the mediation fails, then it will escalate to arbitration. No one wants to get into the court litigation. Okay, so is everyone clear with this? Hello?
Yes. Guys, can you please unmute yourself and let him know?
Okay, I will move ahead. Can I move ahead?
Yes, sir. Yes, sir. Please.
Okay. So basically, what are the career opportunities in arbitration? See, arbitration offers a very diverse career opportunities. So first one is the arbitration council. So in this, the council, that is the lawyers, represent the parties in arbitration proceedings, that is before the arbitral tribunal. The second one is an arbitrator, wherein an arbitrator is a neutral person who decides the dispute. Then there is a tribunal secretary who assists the arbitral tribunal. There is also a case manager who administers working with the arbitration institutions. Then there is an arbitration researcher where they want to research any law points or any aspects which is very crucial to the arbitral tribunal. Then there is also scope for mediator who specializes in dispute resolution. This mediation level is like wherein if there is any dispute, then it first escalates to the negotiation, then to the mediation, and then to the arbitration. So if the dispute is settled in mediation, then it is well and good. It doesn't goes into the arbitration level. So for a young lawyers, if you want to start up your career, then you can start up your career as a tribunal secretary or as an arbitration lawyer, because you get hands-in exposure into arbitration cases. So basically, what is the role of an arbitration counsel? The arbitration counsels are the lawyers who represent the parties during arbitration proceedings. They render the legal advice, then they draft the statement of claim. If you are representing from the sides of the respondent, then you can file the statement of defense. Then you also prepare the evidence and the witness statements. Then you also conduct the cross-examination of the witness. Then you present the legal arguments before the arbitral tribunal. You also draft the written submissions. So these are all the roles of an arbitration counsel. And most obviously, there should be a good drafting skill required. So if you want to start up your career, you please start up your career into a good drafting skill. You develop a good drafting skill. So I'll be also discussing about how you can go for this drafting skill and why it is very useful. So basically, what is the role of an arbitrator? An arbitrator acts as an independent and a neutral person who decides the dispute. A person who conducts a fair hearing. A person who manages the arbitration processes. He ensures that there is a fair neutrality and a fairness into the hearing system. He considers the arguments of both the sides, and then he issues a final award which is binding on both the parties. So basically, an arbitrator is an independent person. He's a neutral person. He doesn't have any interest before any outcome, before any parties. So we say as a neutral person who is an arbitrator. So basically, what are the essential skills for arbitration practice? The first one is that you should be thorough with the contract law, because there is a good drafting required for an arbitration clauses. You require a good drafting expertise, knowledge of contracts. If the contracts are very much proper, then it will not escalate to a very extreme level. Your dispute can be resolved into a negotiation level. Your dispute can be resolved into a mediation level. Your dispute can be resolved into an arbitration level, rather than going into a litigation. So there is a thorough knowledge and a strong knowledge of contract law. A good drafting skills can help you in this. Then you should have a drafting skill. Secondly, you should have a good advocacy and an argument skills. If the matter is going to a mediation, then you can also represent as a counsel of the client, and you can represent your case before the mediator. Okay. In the second scenario, you can also act as a counsel before an arbitrator. And you should have a thorough knowledge of an arbitration law as well as the institutional rules. Every institution have their own rules, so you should have that knowledge also. Secondly, yes, why I say that contract law should you should have a knowledge of the contract law, because if suppose there is a breach, then what will be the penalty clauses, whether there will be any liquidated damages, then what if there is a breach, then whether it has a termination clauses which says about the damages, penalties, interest. So such type of contract drafting skill is much required for a person to, if a person wants to build a career into an arbitration level, in an arbitration practice. So basically, if you are good enough into a legal drafting, then it will surely help you for drafting the statement of claim. See, basically, whenever a claim is filed before an arbitral tribunal, a claim has to be filed, that is, a statement of claim has to be filed by the claimant side before an arbitral tribunal. Then the respondent is given an opportunity to file the statement of defense. Then after that, there is a counter claims and replies filed. Then there is a written submissions. After going with all the documents, then an arbitral award is passed. So you should have a thorough knowledge of the arbitration laws. You should have a good drafting skills, which will help you to build your career in arbitration. And you should always improve your drafting skills. And you should always have a good opportunity. See, whenever you get an opportunity in participating in arbitration moot competitions, you should participate in arbitration moot competitions, because you will be given an opportunity to act as a counsel. You will be given an opportunity to act as a counsel of the claimant. Sometimes you will be given an opportunity to act as a counsel of the respondent side. Then you will also gain an experience as to how to draft the claims, how to draft the written submissions. So with this, you will get a good exposure into an arbitration, arbitration practice. Yeah, one more thing that is just I was speaking with, that arbitration moot competition plays a very vital role, because with this you learn as to how you have to draft the legal submissions, how you have to present the case before an arbitrator, before the arbitral tribunal, how the arbitration proceedings function. So with this, the arbitration moot competitions plays a very vital role in developing your skills. Now, speaking with an route, that is tribunal secretary. So basically, as I said, the tribunal secretary assists the arbitral tribunal in conducting arbitration proceedings. So you can say that an tribunal secretary gets hand-on experience of arbitration matters. This role allows the young lawyers to gain direct exposure to arbitration practice. And tribunal secretaries assist arbitrators in administrative and research tasks. So if there is anything to be researched, if there is anything to be researched for the contract law, or for law, or for basically a law of the international law, then this tribunal secretaries plays a very vital role in managing the arbitration proceedings. So coming to the next, as to what are the responsibilities of tribunal secretary. The responsibilities of a tribunal secretary are that they conduct the legal research for the tribunal. They assist in drafting procedural orders. They manage the arbitration documents and case records. Then they organize the procedural meeting and hearings. They also manage as to when will be the next date of hearing. They organize everything. They assist the tribunal in preparing the arbitral award. So this is the responsibilities of the tribunal secretary. So this role provides a valuable insight if you want to work into an arbitration. Now, you all must be thinking as to how you can join as a tribunal secretary. See, for joining as a tribunal secretary, there are some training programs which are being conducted by certain institutions. So if you clear the assessment and if you undergo the training programs by the institutions, then you will get a certificate of tribunal secretary, certified tribunal secretary. And by this way, you can approach the institutions to get appointed as a tribunal secretary. So there are some institutions which I'll be naming you. You can also write it down in your notes. The first one is a SAMA. If you will Google, then you will come across with the first institution, that is SAMA. SAMA also organizes some online dispute resolution courses. So if you undergo such courses, you can be appointed as a case manager into this arbitration cases. SAMA has a huge volume of arbitration cases, and you can be appointed as a case manager, but you have to clear the assessment. You have to undergo the online dispute resolution courses, and these courses you have to undergo from these institutions to get it appointed as a case manager. The second one is the Mumbai Center for International Arbitration. So here also they conduct the tribunal secretary courses. So you can undergo such training programs from these institutions. The third one is Hong Kong International Arbitration Center. They also conduct the tribunal secretary training programs. The fourth one is the Swiss Arbitration Association. They also conduct the tribunal secretary training programs. So you have to keep an eye as to when they come out with the training programs, and you can enroll with such institutions. Then the last one is KFCRI, which is a Cowais Foundation Conflict Resolution International. This is also an institution, and they offer they come out with a tribunal secretary training program. So you can undergo such training programs from these institutions. Is everyone clear?
Yes, sir.
So moving next.
Yes, sir.
Yes. Any doubts? Any questions? Is anyone having any doubts or questions? Not able to hear anyone.
Guys, respond please. Hello.
No questions, sir.
No,
Okay.
sir. Yeah.
No question, sir.
Okay, so I'll proceed ahead. So basically, the case manager is also a very vital role in arbitral tribunal. So you can also build your career as a case manager. See, case manager and tribunal secretary sounds alike because some of the institutions say as a tribunal secretary and some of the institutions say as a case manager, but the roles and responsibility more or less match with the same things. Okay, so the responsibility of a case manager is that they receive the arbitration filing. So whenever there is an arbitration case filed, then they look after the case, then they communicate with the parties, and they look after whether it is all as per the procedural rules and regulations, whether it is as per the timelines. Is everything being mentioned to the parties? You have to do as per the procedural rules and regulations. Then they schedule the hearings as to the what will be the next date of hearing. They also prepare the case records, digitally getting scanned on the systems and emailing them to the parties, then also communicating to the arbitrator. So this is the roles and responsibilities of a case manager. So the case manager plays a crucial role in ensuring that the arbitration proceedings run effectively. And with this, you get an hands-on experience in arbitration matters. Now, everybody must be having a doubt that why the businesses choose arbitration over the courts. See, nowadays, no one wants to get into the litigation because if there is a civil matters, it takes years and years to get the final order from the court. But into an arbitration, the arbitrator gives an award less than a year. So businesses nowadays wants to go into an arbitration rather than going into a traditional court litigation for resolving their commercial disputes. There are many of the key reasons why businesses choose arbitration into their contracts and why they want to go into an arbitration rather than going into a traditional court litigation. The first aspect is the confidentiality. In arbitration proceedings, all the proceedings which conducts into an arbitration, they are conducted privately and they are confidential. Whereas if you will see into the court, it is not confidential and it is not private. You can easily come across with the judgments, you can easily come across with the court hearings. So this is the main aspect why people want to get into an arbitration, because there is a confidentiality maintained in arbitration. Second one, there is a faster resolution. Court litigation, as everybody knows, court litigation take many years due to the backlog before the courts. But an arbitration resolves the dispute in a year. So in arbitration, the disputes get resolved in a faster and a flexible time manner. So this is a very important aspect why business choose arbitration. Then there is an expert decision makers. Parties appointed arbitrators who has an expertise in a specific industries. Say for example, there is a dispute in construction level. Then they will choose an arbitrator who has an expertise into construction, infrastructures, or shipping, or banking, or technology. So there are different expertization wherein they can choose an arbitrator based on their expertise. Then there is a neutral forum for international disputes. So basically, in cross-border transactions, people may not want to litigate into the courts of the other party's country. So arbitration provides a neutral forum with mutually agreed arbitrators and venue. So in arbitration, you can decide the seat. You can also decide where this arbitration should be conducted. So there is a party autonomy. Here, a party has a freedom to choose all such things into the contract and into an arbitration. Basically, in arbitration, the parties can decide the timelines. They can also decide the hearings, when the hearings can be scheduled, and what can be the language of the proceedings. So this type of freedom is there, and these type of things the parties can choose into an arbitration. As I rightly said, that there is a party autonomy. So parties have the freedom to decide the key aspect, that is selection of arbitrators, seat and venue of arbitration. If you make any mistake into a contract drafting, there have been numerous cases over the seat and a venue. So basically, seat governs the jurisdiction, where if there is any dispute, then it will go before which court. So the seat is a very vital, important role. Say suppose, I'll take you an example. If one of the party is not giving a consent to appoint an arbitrator, and the seat is at Mumbai, then the party will have to approach under Section 11 of the Arbitration Act before the High Court to get an appointment of an arbitrator. But it should be at a Bombay. Why? Because seat is mentioned as a Mumbai. So seat plays a very vital role. and there should be a very good drafting skills while drafting an arbitration clauses, because I've seen many of the judgments wherein if there is any mistake in drafting a contract, or if there is any mistake in drafting of arbitration clauses, and if you make any mistake in seed and venue, then it goes into a court litigation. So to avoid this, you should have a good drafting skills. Secondly, these arbitral awards are enforced in over 170 plus countries, and the arbitrator award is binding on both the parties, like a court order. So it is just like a private court wherein the parties appoint a neutral person, and the neutral person gives a award which is binding on both the parties. That is why the businesses nowadays choose arbitration over the court litigation. So there are numerous arbitration courses also for the students. So if you want to act as an arbitrator in future, then you can enroll into such courses, and you can clear such courses, the assessments of such courses from these institutions. So, I'll be telling you the institutions' names. The first one is the Chartered Institute of Arbitrators, that is CIARB. So they have the numerous training programs. Herein you can be certified as an arbitrator, or a fellow or a member of an arbitrators. So there are numerous training programs being conducted by this CIARB. So I'll recommend that you should surely do such training programs from these institutions. Then the second one is SIAC Academy, that is Singapore International Arbitration Center. They also conduct the arbitration courses. The third one is King's College London. So you can visit the website, that is kcl.ac.uk, and from that you can come across with the tribunal secretary courses, you come across with the arbitration courses. So you can also enroll with such arbitration courses if you want to build your career in arbitration. Then into the fourth, there is a Saudi Center for Commercial Arbitration. They also conduct the training programs for the arbitration courses. So these courses will help you to develop the practical knowledge of arbitration practice. Yes, coming to the next one, I will be also stating why mediation is very important. See, mediation is very important because in a contract, there is always mentioned about first aspect, that is negotiation. If the negotiation fails, then the parties will approach for a mediation aspect. If the mediation fails, then it gets escalated to an arbitration. So mediation is also very important, because if your matter gets settled into a mediation, then you need not have to escalate your matter into an arbitration level. But in mediation, the mediator never gives an award. It only facilitates the dispute between the parties. So he will only facilitate the dispute. He will not give any award. He will not give any orders. So this is the importance of a mediation. Yes, the benefits of mediation. Yes, you want to ask any question?
What is mediation?
Yes, mediation is where there is a neutral person who acts as a mediator. Okay. In arbitration also there is a neutral person who acts as an arbitrator. But in mediation, there is a neutral person who acts as a mediator. He only facilitates the settlement between the parties. He doesn't give any award. Whereas in arbitration, a neutral person decides the case and gives an award which is binding on both the parties. So in mediation, a neutral person will only facilitate the settlement between the parties. If the parties do not reach a settlement, then they can get into an arbitration. Okay. And in mediation, it is also a very faster dispute resolution, because in 2 to 3 hearings, maybe in mediation, the matter can be resolved quickly. Okay. And it also saves the cost of the parties rather than going into arbitration, rather than going into a court litigation. And there is, but obvious, a confidentiality is maintained. Whatever you discuss into a mediation, you cannot bring that aspect into an arbitration, or you cannot bring that aspect into a court litigation. The whole process remains confidential in mediation. So, any questions?
No, sir. Thank you.
No, sir.
Sir, like mediation and arbitration, we get, sir, but like what about conciliation, sir?
Yes, you are not. Can you repeat?
Sir, mediation, arbitration, and one more term, conciliation. Sir, could you explain that related to this?
Okay. See, in conciliation, it is also like facilitating the settlement between the parties. But the conciliator proposes the settlement terms, whereas the mediator never proposes the settlement terms. He only facilitates the settlement between the parties. In conciliation, the person proposes the settlement terms. So that is only the difference.
Okay, sir.
Any questions?
Sir, along with it, sir, could you please explain the negotiation term?
Yeah, in negotiation, there is no mediator, there is no arbitrator, there is only a counsel and a client. Okay, so basically, if there is any dispute, then the parties they sit across on a table and they try to negotiate on the certain aspects. They first make the agenda of the negotiation. So they will say that yes, we want the compensation. So that will be the first agenda. If there is any IP infringement issue, then they will be discussing that second aspect. If they want to have any other new agreement on a new terms, then that will be the third agenda. So these agendas are prepared into a negotiation aspects, negotiation rounds or negotiation sessions, and accordingly, both the parties try to negotiate. They try to resolve the disputes between them, as if they are discussing between both the parties. And there will be always a counsel who will render a legal advice, whether it's very feasible to take such steps or not. So negotiation means they are trying to negotiate the aspect which have the dispute internally. There will be no mediator, there will be no arbitrator, only parties and a counsel. Is everyone thorough with this doubt?
Yes, sir.
Yes. See, if you want to build a career, there are numerous negotiation competitions. So you can enroll yourself in negotiation competitions, wherein you will get some experience as to how you can negotiate your dispute to another party, how you can try to settle it internally. So you can enroll into a negotiation competitions. You can also enroll into mediation competitions, where you will be acting as a party initially. You will also be acting as a mediator. So you will get an exposure as to how the mediation takes place. Okay. Then there is also an arbitration moot competitions, wherein you will be assigned a case that is a moot competition case, and you will have to present the case before an arbitrator. So you will have to prepare the written submissions and the way you present your arguments before an arbitrator. You will get all such experience and an exposure. So if there is any competitions you come across into in Google or you come across into a LinkedIn, then you should surely enroll into such competitions, because it is not like winning or losing any competition. It is like you are developing the skills into negotiation. You will be developing your skills into mediation. You will be developing your skills into an arbitration. So enroll whenever you see such competitions. Enroll yourself. Okay. Any questions?
No, sir.
Okay. So moving ahead. Yeah. So you all must be having a doubt as to how we can get the mediation training. So the students can obtain the mediation training from the institutes. That is London School of Mediation. You can visit the website. It is londonschoolofmediation.com. Then there is a Singapore International Mediation Center. Then the third one is an ADR training institutes, wherein you can see that there are IM campus. Then there is other institutes which do gives the mediation training, that is YCM. So you can see on the Google as well. Then there is a National Legal Services Authority, which is wherein in India they have launched. In India, the courts have launched these programs, wherein they give the mediation trainings to the legal professionals. So you can also enroll yourself into National Legal Services Authority. You can visit the site, that is nalsamediation.nic.in. Then there is also an institute named as Mediate Guru. So they also conduct the mediation training programs. Then there is an ILS Law College, which is at Pune. So over there also, but these type over there also you can enroll into the mediation training programs. But all the training programs are conducted online also. So this is a very convenient way and a good way, wherein you need not have to travel all the way to the institute or whatever. You can get access to the mediation trainings on an online forums, online platforms. And this mediation training will surely develop your skills. Okay. So moving to next. See, I am an ILA president of a Thana chapter. So one more advice I'll give you, that you be a member of organizations, you be a member of associations, because whenever you fill a form for empanelment as an arbitrator, or for empanelment as a mediator, or for empanelment into any consultant or a counsel, so there is always a column for membership, And if you do not mention anything into a column of membership, then the people will think as if you do not have that sufficient practice or you do not have that practice into a law. So I will surely advise you that you should be a member of organization, you should be a member of associations, and being a member of such organizations or an association, there are numerous benefits. So one of the benefits I'll be telling you with this, some of the screenshots. So one of the very key important role is the Indian Lawyers Association. So if you become a member of this Indian Lawyers Association, there will be good advantage for you. So basically, the Indian Lawyers Association is a professional body of legal practitioners dedicated to promoting legal knowledge, professional development, and collaboration among members of the legal community. So this association brings together the advocates, arbitrators, mediators, legal professionals, and law students. So even if you are a law student, you can get a membership, and it is open to the membership is open to the lawyers, judges, professors, law students, and other interested in the law and in the legal profession. So this way you can enroll yourself as a member of an association, and it will have a very good benefits. I'll be telling you about the benefits also. So basically, the objective of the association is to strengthen the legal profession through knowledge sharing, professional networking, and skill development. The Indian Lawyers Association provides a platform where legal professionals can interact, exchange ideas, and stay updated on developments in law and dispute resolution. So basically, the Indian Lawyers Association also conduct various seminars, workshops. They also conduct events, and there will be a good professional networks where you can have a good professional networks of the lawyers throughout the Indian levels. You can also attend the seminars. You can also have an opportunity to attend the event, and by attending such sessions or any events, you gain knowledge on the recent legal developments. So this is very beneficial if you are the member of an association. And as and when you gain a very good professional network, then the work starts flowing to you, because in this legal profession, there should be a very good professional network. And if you have a very good professional network, then the people will recognize you and your work, and the work will start flowing to you. You will be assigned the matters from another lawyers also. You will be assigned matters from the clients. They can refer your name to any clients. So these are the ways wherein you can work jointly with the lawyers, jointly with the legal professionals, if you are the member of any association. So as I said, that building your professional network is a very important aspect in legal professionals. You meet experienced lawyers, you meet experienced arbitrators, you build professional relationship, you gain mentorship, then you learn about practical aspect of legal practice. So over the time, these professional networks often lead to new professional opportunities and legal assignments. So this is a very key aspect if you become a member of this ILA association. So basically,
A law student can join.
yes, as a law student, you can. The membership is open to the law student also. You can join as a member before the Indian Lawyers Association. You can visit the website. I've already shared the website link. That is indialawyers.org. So you can visit this website. You can join as a law student, and you can be a member of this Indian Lawyers Association. And it is very beneficial, because when after 10 years or after 15 years you want to start up your own individual practice or whatever, if you want to get empaneled as an arbitrator, if you want to get empaneled as a mediator, if you want to get empaneled as a counsel or a consultant for any companies, then they always has a form that whether you are a member of any institution or whether you are a member of any organization. So this will play a very vital role if you become a member of such organizations, if you become a member of such associations. Any questions?
No, sir.
No, sir.
Okay. See, many of the membership come in a different ways. That is student membership. Then there is also an annual membership where you have to pay annually. Then there is a young professional membership. If you are aged below 40 years, then you can become a member into different arbitration institutions. That is, one of them is Singapore International Arbitration Center, then Hong Kong International Arbitration Center, then there is London Court of International Arbitration Center. There are numerous international arbitration centers which offer a free membership to the young professional who are aged below 40 years. So you can become a member of that institutions. That is a young professional membership. Then there is also a life membership. So there are many institutions, many organizations where instead of paying an annual membership, you can pay a one-time lump sum amount. It will be the life membership amount. So irrespective of many years, you will not be having any bother of paying annual membership. It will be only a one-time life membership. So you can opt that also. After coming into our advocacy package also, you can take life membership or an annual membership of the courts. That is Court Bar Association, Family Court Bar Association, Civil Court Bar Association. So you can also become a member of that Court Bar Association. Okay. Different courts have the membership, so you can become an annual member or you can also become a life member. So with this, you will gain a very good benefit into future aspects. Yes, as I already stated, if you are young and if you are aged below 40 years, then you can become a young member of the arbitral institutions. And it has a very huge benefits because the arbitral institutions also conduct webinars, they also conduct workshops, they also conduct events. So you can enroll yourself into such events, you can enroll yourself into such sessions, and it will be a very good aspect because you will gain knowledge. So, and you will also have a good professional networks. So with this, I'll surely recommend that you should become a member of arbitral institutions. You should become a member of Indian Lawyers Association. You should become a member of court bar associations, that is family courts, civil courts, criminal courts also have a bar association. So you should always enroll yourself after getting into an advocacy practice. You should enroll yourself into into such association as a member. Any questions?
No, sir.
Can I proceed ahead?
Yes, sir, surely.
Yes, sir.
Okay, so I'll show you the roadmap. If you are a law student, then you can participate into arbitration moot competition. As I rightly said, that if you want to build a career into an arbitration, then you should start participating in arbitration moot competition. Start participating in negotiation competitions. Start participating in mediation competitions. Then you can act as an intern with arbitration practitioners who are the arbitrators. So you can act as an intern and you can gain some experience from arbitrators also. Then you can attend the arbitration seminars or events which are being conducted by institutions. So you will gain some knowledge. Then you can take arbitration mediation training courses. As I rightly stated, there are different institutions who come across with such training programs. So you should enroll on the arbitration and mediation training programs. Then you should always read the judgments of the Supreme Court of India, High Courts of India on arbitration cases. With this, you will get the knowledge on arbitration laws. Secondly, start writing articles and research papers on arbitration law. So with this, you will gain much knowledge into an arbitration field. You will become an expertise into an arbitration field. So do such things. Then, after I also tell that if someone wants to become an independent arbitrator or an independent mediator, then there is a requirement that you should gain an experience in dispute resolution for a minimum of 10 years. This is a requirement. So, as a lawyer, you should gain experience for the 10 years as a counsel, then into dispute resolution, then enrolling yourself into mediation competitions. After gaining 10 years of experience in acting into arbitration mediation matters, wherein you will also get an opportunity by enrolling yourself into tribunal secretary courses, enrolling yourself into case manager courses, appointing as an tribunal secretary, appointing as a case managers. So with this, you will get an hands-on experience into arbitration and mediation matters. Gradually over the years, that is 10 years, then you can be empaneled as an independent arbitrator and a mediator before various institutions, internationally also. So with this, I can surely tell you that if you build your career from the day one, then you will surely get a success. But it will take slowly and gradually. But you have to gain an experience and you have to surely develop the skills. So attend moot courts competitions, attend mediation competitions, training programs, and over a gradually of 10 years, you will gain much experience into this field, that is dispute resolution field. And after that, you can act as an independent arbitrator and a mediator. So with this, I conclude my session, and I would surely tell to all the students that you should start up your practice into an arbitration, because in arbitrations and in mediations, that is in ADR, the dispute can be resolved time effectively, that is within a year. But whereas if you go into litigations, or if you take up the matters into a litigation, then it will take years and years. So I think you should choose your career into, you should build your career into an arbitration, you should build your career into mediation. With this, you can resolve the disputes at a very time effective manner, rather than going and spending your years into litigation, spending your time, money and energy into litigation. So with this, I will be concluding my session, and I surely believe that you all would surely be having a very good interest into an ADR by what I have said in this session, and I hope that you will flourish into your legal profession. Any questions you have?
Guys, do you have any doubts or any questions? Sir, some of them are asking for the PPT. Can we share it with them?
Just a minute, madam.
Yes, yes.
Yes, madam, you were saying something.
Yes, sir. I was saying that some of them are asking for the PPT. Can we share it with them?
Yes, I can share them the PPT. Yes.
Okay, sir. Now, I guess Abhijit have some questions. So, you can proceed, Abhijit.
Yeah, hi sir. My name is Abhijit. So I'm studying in RV College. I'm in my final year. So I have worked with Sama as a case manager for maybe 1 or 1.5 years, something like that. So I do know how this ADR process works. And in my college only, they provided me the ADR Pros training program. So I am a little bit good at this thing. So now I have a little basic number of knowledge in this ADR thing. I want to know how to proceed in this particular field, because it is very interesting, and it has a vast number of scope around the world also. That is what I feel, and I am little bit stuck how to go forward with this, sir.
See, if you are acting as a case manager, then it's a very good aspect, because you will get a hands-on experience into numerous matters. And if you're acting as a case manager, then you will be coordinating with the parties. You will also be coordinating with the arbitrators. And whenever the claimants will file the statement of claim, then you can come across with the statement of claim. If the respondent is appearing into an hearings, and if they are filing the statement of defense, then you will come across the reading of the statement of defense also, by reading of the statement of defense. So you will get a majority of the exposure as to how the proceedings takes place into an arbitral tribunal, how these are conducted. And by gaining such experiences, you will, after years, you can also act as an independent arbitrator by enrolling into arbitration training programs, more and more arbitration training programs. So with this, what you are currently doing as a case manager will benefit you in future, because you are getting hands-on experience of arbitration proceedings.
Okay, sir. But to add on to this question is, when I did an internship in an IPR firm, so most of the cases over there was handed over to the they wanted to put it in a litigation thing, like normal court traditional way, rather than sending it to an arbitration or this arbitration thing. So I didn't know the methodology why they chose the traditional court way rather than a speedy thing.
See, I'll answer this question because, as I rightly said, that the contract should be well drafted and you should have a good drafting skills. So in a contract, if the clause clearly mentions about the dispute resolution, and if the clause clearly mentions if there is a dispute, then it will be first tried into a mediation, and if the mediation fails, then it will be tried before an arbitration. Then the parties have the right to choose the arbitration. But if your contract doesn't speak about the dispute resolution, if the contract doesn't have an arbitration clause, then but obvious the parties will have only one option, that is to go before the court, that is the litigation. So if you want to get into an arbitration, you should have a arbitration clause, which is a very mandatory.
Okay.
So I think if the agreement doesn't have an arbitration clause, then but obviously you cannot take it into an arbitration. So I think whatever you must have seen, they must not be having an arbitration clause. That's why they must have approached before the course. That is the main aspect. So if you want to get into an arbitration tribunal or into an arbitration, then you should have an arbitration clause.
Okay. Thank you, sir.
Okay, guys, any further questions?
Any questions?
I guess no. Okay, thank you so much, sir, for taking out the time and guiding us today. It was really an insightful session, and it was truly an honor to have you with us today. So thank you so much for joining us.
Thank you. And one more, madam. We'll take a screenshot. Yes, you
Sure.
can take a screenshot now. Everybody can turn on your cameras.
Yes, sir. Guys, can you all please turn on your camera for just 1 minute? Shweta, Revan, Aisha. Okay, done.
Okay, thank you for attending this session. If there is any doubts, if you want to connect with me, you can connect with me on my LinkedIn profile. So you can connect with me to my LinkedIn profile. And if you have any doubts, I'll surely assist you with all the doubts. Wish you all the best, and I hope that you all flourish into a legal profession.
Thank you, sir. Thank you so much for joining the session.
Thank you. Thank you. Thank you. Bye.
Okay, guys, thank you so much for joining the session. I hope it was insightful and helpful for you all. And if you have not filled the feedback form yet, you can fill out it, because without filling that form, we won't be able to give you the certificate of the session. So fill it at the earliest, and I guess you will be getting your certificate by 11 p.m. most probably, or by tomorrow morning. So yes, thank you so much, guys. Now you may leave the session.